All four of the plaintiffs' groups filing their latest briefs in the Seventh Circuit U.S. Court of Appeals challenging Illinois' gun and magazine ban, as you've got more Illinois laws in the hopper to restrict and regulate law-abiding gun owners. It is Illinois in Focus Daily. I'm Greg Bishop. Wake up with us each and every weekday morning. Join the live chat. Get segments of the show throughout the day at the Center Square on YouTube. But also get the podcast where you get podcasts. Just search Illinois in Focus Daily. So we're talking about the Caleb Barnett et al. Case. That is a consolidated case out of the Southern District of Illinois, where last fall, a federal judge in the district court, Stephen McGlynn, he found that Illinois' law that prohibits the sale and possession of 170 plus semi-automatic firearms and magazines over certain capacities violates the Constitution and the Second Amendment, right, to keep and bear arms. So that was after a pretty lengthy 4-day bench trial of a lot of testimony concerning everything from, the quality of the metallurgy on firearms that are used for military purposes versus those who are available for the civilian market. A lot of questions about the AR-15 and similar types of platforms, the AK-47. So pretty detailed record. And that case is in the appeals court. Now, we reviewed the state's response to the federal judge, and now it's time for the plaintiffs to respond to the state and the federal judge. So we'll go through that now in just a little bit of a cursory overview. So let's go ahead and pull this up. This one is the appellees in this particular circuit court, the Seventh Circuit. This is Dane Harrell et al. For the plaintiffs. Just one of the filings here. We're going to look at some of the overviews and the table of contents, and then we'll break out some of what Thomas Magg has had to say in his filing for his plaintiffs group. So here we go. We've got the jurisdictional statements and such, but just the arguments overview. Gives you kind of an idea of how they're going to argue this when they do have oral arguments. And just a quick note, one attorney for the state has already said that they cannot be available for oral arguments between September 3rd and the 18th. So that's an indication of when we could possibly see oral arguments or when we may not see those oral arguments. But anyways, back to the table of contents here. This court should affirm based on Heller, Bruin, and Rahimi. So it is pointing to recent U.S. Supreme Court rulings on availability of handguns, the Bruin decision out of New York, and the Rahimi case concerning due process in stripping somebody of their Second Amendment rights. Talks about the Bevis case as well, saying it's fundamentally incompatible with the Supreme Court precedent. And that's a decision that was made by the Seventh Circuit in the Bevis case. And that case, by the way, is still stuck in the district court. And I think they've held off on any future hearings until these cases are dealt with. The term arms covers all handheld weapons, not exclusively civilian weapons. The plaintiffs group here says no historical evidence or analog supports banning commonly used rifles or their standard magazines. They also go through what dangerous and unusual means, what arms in common use means. They delve deeper into the Bevis case. And they say rejecting Bevis accords with Seventh Circuit practice. And they say this case is straightforward under Heller and Bruin. You've got another table of contents from the second plaintiffs group. This is goes into the Protect Illinois Communities Act, how it was passed, the Bevis case, and a variety of other precedents that they're arguing here. But they say that the state identifies no reason to disturb the district court's evidence-backed conclusion that firearms PICA bans are arms. The district court did not clearly err in finding that ordinary people would and actually do keep for self-defense and other lawful purposes the firearms PICA bans. The state does not contest that any of the evidence showing that the firearms PICA bans are firearms that ordinary people would find useful for self-defense. The state does not contest that any of the evidence showing that ordinary people do, in fact, keep for self-defense the arms that PICA outlaws. Further says that in the overview, the state's contrary arguments ignore the laws, the facts, and what makes a firearm unlawful under PICA. And the district court did not clearly err in finding that firearms PICA bans are neither exclusively nor predominantly used in military service. They further argue that the state identifies no reason to disturb the district court's evidence-backed conclusion that magazines PICA bans are arms. So it goes into the magazines issue. The district courts correctly concluded that the state failed to identify any tradition of banning ubiquitous non-militaristic arms. The arms PICA bans are not dangerous and unusual. There's no historical tradition of banning common non-militaristic arms that millions of law-abiding citizens own for lawful purposes, and they say Illinois cannot save PICA's sweeping ban on common non-militaristic arms by pointing to some dramatic technological change or novel societal problem. And that's going right to the argument that the state has that these are military-grade type weapons, and societal concerns for mass shootings causes the legislature to do what they did. So they ultimately break down their conclusions there. Now, the third overview of the arguments from a different plaintiffs group in the case Barnett and against the state of Illinois, they say the district court correctly held that PICA's firearms and parts bans violate the Second Amendment. The district court correctly held that PICA's restrictions on firearms parts violates the Second Amendment, and the district court correctly held that PICA's registration requirement violates the Second Amendment. And that's the case coming from the Federal Firearms Licensees of Illinois. Then you get into the plaintiff's brief that Thomas Magg filed on behalf of the Langley plaintiffs. And he says, with absolute certainty, it can be said, New York State Rifle and Pistol Association v. Bruin largely overruled every Second Amendment case that this court has considered in which it upheld a statute or restriction simply by virtue of the fact that this court, like many others, was applying a standard that Bruin rejects. Applying Bruin correctly, as stated by the Supreme Court itself, we reiterate that the standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it's consistent with the nation's historical tradition of firearms regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Just as the First Amendment protects modern forms of communications, the Fourth Amendment applies to modern forms of search. The Second Amendment extends prima facie on its face to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. It also goes through some of the language in Heller. The Supreme Court undertook its first ever in-depth examination of the Second Amendment's meaning. After a lengthy historical discussion, the court ultimately concluded the Second Amendment guarantees the individual right to possess and carry weapons in case of confrontation. That's central to the right is inherent rights of self-defense, that the home is where the need for defense of self, family, and property is most acute. And that, above all interests, the Second Amendment elevates the right of law-abiding, responsible citizens to use arms in defense of hearth and home. So reaffirmed, the modern devices and arms not common at the time of the Revolution are indeed protected by the Second Amendment, as literally noted by unanimous Supreme Court just hours before the filing of this brief. Some have referred to these items as military-style assault weapons, among which it is included AR-15 rifles, AK-47 rifles, and .50 caliber sniper rifles. But those products are both widely legal and bought by many ordinary consumers. The AR-15 is the most popular rifle in the country. So that's from the recent ruling that came out of the case Smith & Wesson versus Estados Unidos Mexicanos. Further goes on to apply Bruin and even more back and forth with the different precedents that are set. So that's just an overview of the four different filings, and we're talking about like 120 plus pages of filings from the four different plaintiffs groups. So the case continues in the Seventh Circuit U.S. Court of Appeals challenging Illinois' gun and magazine ban, and this is going to be interesting to watch how it unfolds because the U.S. Supreme Court denied hearing a challenge to Maryland's gun ban. Then the same day, you had the Viramontes case out of Cook County be decided by the Seventh Circuit U.S. Court of Appeals that upheld the district court's ruling that the state's ban and the Cook County ban is constitutional. So that case, Viramontes, could go to the U.S. Supreme Court. Now, of course, they could possibly sit on it and say, we're not going to take this one. It's not as strong as, say, the Barnett case here. which the Barnett case out of the Southern District has a very detailed record after a 4-day bench trial and a district judge finding it unconstitutional. So is that the case that's ultimately going to go to the U.S. Supreme Court next after the federal appeals court decision? We don't know yet because the timeline here is still uncertain. Now, the plaintiffs groups responded to the state, but how this works is the state then gets to respond to the plaintiffs groups, and then we'll get oral arguments scheduled. When that'll be, could it be this fall? When they schedule it after a hearing, how long is it going to take for them to rule on this and then get it to the U.S. Supreme Court? So it possibly could be sometime in the spring before the Seventh Circuit U.S. Court of Appeals actually deals with the merits of this case. Because keep in mind, this is on the merits of the case. This is something that has gone all the way up to the U.S. Supreme Court on preliminary grounds, where they were asking for a preliminary injunction. It was granted by the district court, but then overturned by the Seventh Circuit, and then the U.S. Supreme Court said they're not ready to take this case because it's not ripe. It was all on preliminary grounds. So it went back to the district court. You had the debate on the merits, and on the merits, the federal judge found it unconstitutional. Now it's in the appeals court. So that's where we're at in the process of the Southern District case challenging Illinois' gun and magazine ban. But could there be more litigation about gun laws? Last night, the several Illinois State House Republicans held a town hall, a virtual town hall, and one of the things they discussed was Senate Bill 8. Here is State Representative Regan Deering, a Republican from Decatur, talking about Senate Bill 8, which is the safe gun storage bill that did pass both chambers of the General Assembly this spring.
Safe Gun Storage Act. I mean, if you drill it down, it's essentially that a firearm owner can't store or keep any firearm on their person or on their premises. I'm going to read the language so I get it right. Where the firearm owner knows or reasonably should know a minor without the lawful permission of the minor's parent, an at-risk person, and I'm not sure
what is that.
Down an at-risk person, or a prohibited person is likely to gain access to the firearm. So a lot of questions from our concealed carry gun owners, people that do store their guns in their car, perhaps for personal protection. Now they have to be in a locked glove box or something, but everything is just so vague. I'm not saying that it's not a good idea to keep your weapons locked, but if you are, for example, I think a big debate was about hunters. If you were taking your hunting rifle with you and you have a minor because you're going out, how do you store that in the back of your car? What does that look like? And so just the intentionality with the vagueness, I think, often gets us in trouble, and like Dr. Howder said, could lead to constitutional violations.
So more about the Safe Gun Storage Act. State Senator Sally Turner laid out some more of her thoughts on this, and even questions of potential litigation coming down the pike if this indeed gets signed and is implemented.
And so that was Senate Bill 8, and what it does basically is criminalizes victims of theft by punishing these law-abiding gun owners who don't report a stolen firearm within 48 hours. And sometimes, as we know, that they have no way of knowing if it's missing because maybe they have it in some other area that they don't go to within every 48 hours. That's kept in some secure safe, gun safe in a cabin or something of that nature, or another area that they have living quarters. And it has hefty fines or losing your FOID card. And I think we all believe that was government overreach. And ignored. And ignored the everyday rights of reasonable, responsible gun owners. And it targets the people that are even doing things right. So those of us in the 44th district, this isn't something that happens for us every day. I don't, up north, maybe that's something that is going on up there, but it's not for our reasonable, responsible gun owners here in the 44th district.
Now, Bill Howder, a Republican state representative from Morton, also sounding off on the safe gun storage measure that passed.
Just another law for law-abiding citizens, and will do nothing to stop gun violence and the criminals. I believe it not only was irresponsible, it was unconstitutional blatantly, and I'm getting to the point where I don't even look at these bills anymore because I know they're going to be in the courts for years, and because they're going to be found unconstitutional, in my opinion.
That's a great point.
It's blatantly unconstitutional. It really hinders your ability to defend yourself in your home. So
Right.
I'm not going to say I don't get excited about these, but I think the Illinois State Rifle Association is just, they're almost to the point where they just say, they throw up their hands and they say, we're just going to not even lobby on this bill because we don't have the numbers, but we do have the Constitution on our side. And so why even work in the state of Illinois on the legislative effort when you're going to take it to the court anyway, because we have the Constitution that will protect us once again. So I think this will be in the court system and it'll be overturned.
Yeah.
Something to watch as we have ongoing litigation against Illinois gun laws, with another gun law in the pipeline getting ready to be implemented, requiring safe gun storage with penalties if you don't report lost or stolen firearms, including the loss of your firearm owner ID card. So we'll be tracking all of this and more. It is Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell. Wake up with us each and every weekday morning